family law matters can be both confusing and frightening. And with all these different questions, it's very difficult to find the source for answers. Well, here's one for you. You can ask Andrew. Ask Andrew is the only online-based call-in show where Andrew Feldstein of the Feldstein Family Law Group makes himself available to answer all of your family law questions. So tune in and ask Andrew.
Welcome to the Ask Andrew show today. It's North America's first family law Facebook Live streaming family law question and answer show. Quite a mouthful. We appreciate you taking time out of your busy day to be here with us today on April 27th, 2017. If you think your Facebook friends will benefit from watching the show, please press share button on Facebook. You never know who's going through a family law issue such as divorce, custody, property issues, any kind of issues with respect to family law. And we're here and we hope that we can help you. Today, we're going to discuss unbundled family law services and what that means. And our guest today is Rachel Williams, and she is a family law lawyer here at Feldstein Family Law Group, and she works out of our office in Toronto in the Bloor West Village. Welcome to the show, Rachel.
Thank you for having me.
My pleasure. So can you tell us a little bit about yourself?
Well, I joined Feldstein Family Law Group about 5 years ago as a summer student initially when I was in law school. And I've been working here since that time. I did my articles here, and now I'm a practicing lawyer in the Toronto office. That's about it. I enjoy live music. I love cooking and just hanging out with friends.
Okay. And what's the most common family law question that you hear from potential clients or clients that you deal with?
You know, you see a lot of different issues come in. So I think the most immediate concern for most people I see is, what is this going to cost me? And how can I reduce costs as much as possible? Of course, the other issue that people come in with is they want to know how their life is going to change, whether that be their time with their children or their financial circumstances.
And what do you see as the number one fear? Do you find people are really scared about how the relationship with the children are going to change?
I do. If children are involved, parents are always worried. I mean, they're used to spending all of their time with their children. So anything less is going to be a difference from what they've had previous to a separation. So I do think that is, generally speaking, the most common concern for clients that come in that are sort of starting to deal with, they might still be in the home, the matrimonial home, but they might be trying to work out an interim or a final resolution that will allow them to spend time with their children.
And how do you deal with them when they ask that question?
Well, I guess I try to find out what historically their involvement with the children and the family has been. You can usually get a sense fairly quickly how much of an involved parent they are. And you can kind of tell when someone comes in, if their immediate concern is the children, then you know that generally speaking, they've been a pretty active parent. So once I get a sense of what their involvement has been, that's where I start to talk to them about what their objectives are, whether they've had any conversations with their spouse about what a parenting schedule might look like.
Okay, and how do you deal with their concerns over financial issues?
Well, again, it starts with getting information. What is their income? Is their spouse working? How are they currently paying for the matrimonial home expenses? Have they already physically separated? And once we gather that information, it's really about, there's the issues of child support and potentially spousal support as well, depending on the circumstances of the parties.
Now, here at Feldstein Family Law Group, as you know, we do unbundled services or limited scope retainers. Could you explain what that means?
Yeah, so often clients will come in and sometimes they'll ask me or sometimes I'll put it to them as an option. But the difference between unbundled legal services and hiring a lawyer to essentially deal with all aspects of your arrangement is that you're hiring a lawyer to deal with a specific task, whether that be attending at a specific court appearance, drafting pleadings, or providing ILA or independent legal advice for a separation agreement that might have been drafted by another lawyer.
Okay, and do you find that clients are hiring you for unbundled legal services?
I do. Frequently, people will come in and, you start to talk about the cost, particularly when it comes to litigation. And it can be quite scary when you talk about, all the work that needs to go into preparing the documents, attending at court appearances, the fact that you need to file up-to-date briefs and financial documents at each court appearance. So I often will suggest to clients, particularly if they've already been served with application materials, that they might want to retain, at least in the beginning, on a limited basis to, draft an answer or to respond to their spouse or their spouse's lawyer. Sometimes people will come in, later on in the proceedings, and sometimes they've had previous counsel. And so they're a little bit more familiar with the process, and they might just want you to attend at a motion or a case conference on their behalf.
I find from my experience, it can really be helpful for clients who find themselves financially challenged. And I always use the scenario of a car. If I want to be driving a car, I want to be in the safest possible car. That might be, say, a Mercedes-Benz or something like that. But if I can't afford a Mercedes-Benz, I'd rather be driving a safe car. And a Honda may be a very safe car, just not as safe. Well, the ideal scenario is for someone to have the comprehensive retainer, which is they hire us to do everything. That's sort of the Mercedes-Benz version. But if they can't afford that, the limited scope retainer unbundled services can be very effective and can achieve good results at a less expensive price. Would you agree with me on that?
I would, absolutely. I think, particularly if you sometimes get files where you meet with the client and you think that they might be sort of close to a resolution, they might be heading towards a case conference or a settlement conference. And particularly in that scenario, it can be a good option to do a limited retainer for that specific event, because you might actually be able to resolve the matter at that event on that day.
I actually remember one client in particular when I just started doing this kind of work, and he was really good at picking his points of when he wanted us for the limited scope retainer. And this was a gentleman who came in, he said, I have a motion to reduce my support. I'm going in front of a judge in a month. And he hired us to prepare the paperwork for him. And we prepared all the affidavit material, his notice of motion for him. And we even gave him some coaching on how to argue the motion. And he got everything he asked for in front of the judge. And he beat a lawyer that was on the other side. So it was a wonderful result for this gentleman. And then about a year later, much like Rachel said, he came back at the settlement conference stage. And he said, Andrew, I'm really close to a deal. I'll pay you for a couple of 2-3 hours to review with me what the issues are. And then can you attend a settlement meeting with me? We did that and we got his case settled. And it was remarkable. And that particular gentleman, he picked the spots. So it was the most effective use of my time possible. And he really got a good resolution of the matter, and he did well on his motion. So in those situations, unbundled legal services can be very effective. But wouldn't you agree people also need to be aware that there are risks of doing the unbundled service? And what type of risks do you see?
Well, when clients come in, they might come in and it might be a very complicated matter to start with. And they might want you to tackle one aspect. And as a lawyer, you have a responsibility to provide proper legal advice. And that can be really challenging, where you're not getting, you're not given the opportunity to review the file fully. You're not, really sitting with the client and dealing with all aspects of their matter. The other challenge is that, people come in and it can be hard to stop assisting clients after a specific event. There are times where a client might retain for a specific aspect of their matter, and then it doesn't settle at that point, and they're sort of in limbo because counsel for the other side is contacting me because I was agent on the matter, but I'm no longer retained. So often I find when clients retain, they really do want you to be involved in every aspect, but that's not what the limited retainer is for.
Well, I find in my experience, the biggest risk that clients have is really themselves. And they're capable of writing a letter or taking a position that's really unreasonable, or preparing a document where they make some huge mistakes in their case that will come back and really hurt them. I'll give a brief example, and then I'm going to go to a question from Lucy that came in on Facebook. And a perfect example is you take somebody who believes they look at the case from a moral perspective. Let's say their spouse cheated, and they write a scathing letter to their spouse's lawyer that, my wife, and I'm being stereotypical here, doesn't deserve any spousal support because she's a liar and a cheater, and I shouldn't have to pay her anything, and who cares that she hasn't worked? I'm not paying. And calls her all sorts of horrendous names. Those things happen because clients will instruct us as lawyers to write that letter, but we tell the client as lawyers, you can't do that. The optics of it are negative, and you're going to look horrible in front of a court. And once that letter goes out, it can be damaging to the client's case. And that's where lawyers can be really helpful, is also vetting the case and being able to appreciate the person's anger and emotions, but also getting them to focus on what's the best result we can achieve for them and how those issues aren't very helpful. Now, the question from Lucy is, how long does it take to get a divorce? Does it take longer to do when you get unbundled legal services? Well, I'm going to start with that there's two different ways when we talk about divorce. One is the uncontested divorce. Whether you're unbundled or not really wouldn't make a difference in an uncontested divorce, because you're filing your application for divorce, and providing you meet the criteria, you're really just pushing paper and filing things at the courthouse. And in that scenario, there really is no issue. It's the second scenario when someone commences an application for divorce, but it has all of the corollary issues that go along with it, such as child support, spousal support, and even division of property. Because when those things are at play, that's what makes a case very complicated. And that's what stretches out the time period to get a divorce, because you're fighting about these other issues. And clients will frequently come to me and say, well, Andrew, why can't I just get the divorce? And the answer, especially when it's a self-employed person, is that you're not eligible for a divorce unless there's reasonable arrangements for child support in place. That's one issue, and that's really important. So if someone's self-employed, the other side says, I don't know what his income is or what her income is, so I'm not agreeing to the divorce because I don't know that reasonable arrangements for child support are in place. That can really stretch out a case. The other problem happens, people can say they want to object to the divorce because when you're divorced, certain things happen in terms of your rights between one another. And a lot of people don't appreciate these. For example, if you're divorced, you no longer have a right to possess the matrimonial home if you're not on title. So if your spouse is the sole owner of the home and you get divorced, you may find yourself out on the street. The other issue a lot of people don't appreciate are benefits. When you get divorced, most benefit providers will no longer consider you a spouse. So whether you're bundled or unbundled in that scenario, it's going to take more time. I would suggest that if you're doing the comprehensive, it's going to be faster than the unbundled version just because we're more involved, but either way can take time. And if it's an uncontested divorce, ironically, it depends on which courthouse you're going to. Toronto has a tremendous number of judges, and if you're able to go to the Toronto courthouse, you're going to get the divorce back much faster than other courts like Newmarket, where the divorce is going to come back slower. And whether you're unbundled or not doesn't really matter. Lucy, I hope that helps with your question. I wanted to circle back to Rachel, what you and I were talking about a couple minutes ago, which was really the advantages and disadvantages of unbundled legal services. And have you seen other advantages or disadvantages in your experience with unbundled legal services?
Other than those already spoken about, I think it can be good depending on the circumstances of the case. So it is a great thing to talk to your lawyer about it and to ask whether it is appropriate in your matter. Too often people wait before they see a lawyer and they're sort of well into their matter. And it's always best to see a lawyer at the beginning, as soon as you separate if possible, or sometimes even before. I actually see a lot of clients come in that are sort of contemplating separation and they'll come to speak with me. And and those people are in the best position to deal with their matter. But in terms of, unbundled legal services, I think it's a great way to reduce costs when you are in litigation, or it can be, because when a lawyer is on the record for you, meaning they are attending at every single court appearance, they are required to go to all those appearances and to prepare all those documents. Whereas when you have an unbundled situation, a lawyer will be able to say, well, we're about to go to a case conference. It's going to cost this much to draft your brief, and it's going to cost this much for me to attend. It's much easier to anticipate costs, and that's a big relief for a lot of clients.
Okay. And I have to add something to what you just said, which is your comment that before you separate, it's a good idea to come in and speak to a lawyer. It's actually a great idea because it gives people an opportunity to plan. And it may sound horrible to say, I'm going to plan my divorce, and a very hard thing to do. But most of the time, a marriage doesn't just end on a moment's notice. It's usually on a declining trend moving towards separation. And if you think you may be moving towards separation, it can be very helpful to get information on how separation impacts you. And the things that I frequently tell people when they actually do come in for that is, number one, is when it comes to the children, the courts do look at status quo. And if you haven't been as involved with the children as you would like to be because the other person hasn't led you or you've been busy with work, if you're thinking of separation, change it. Create a new status quo before the separation takes place. So if your partner has been more active, be super dad or super mom for whatever period of time that you can. The second thing I've said, and this one sounds ironic, is there's a funny rule in the Family Law Act which says if you own a home on the date of marriage and you still own it on the date of separation and you're actually using it as a matrimonial home, as you know, Rachel, you can't deduct it from your net family property. So that would mean the equity you brought into the marriage is going to be shared. And I've had many people who've come into initial consultations and they've said to me, you mean I'm going to have to share my house with what I brought in with my spouse? And I go, yeah. I've seen some of these people come back 2 years later and they tell me they went home, they spoke to their spouse and said, I think we need to try and start fresh and start new. And maybe the smartest thing we could do is sell our house and start fresh somewhere else in a new house that we jointly picked out together. Now, all of a sudden, they actually get credit for the equity they brought into the marriage. So some people will actually take steps to adjust. And with what real estate's worth in the Toronto area, you can understand why people would do that. Now, I see we have another question on Facebook Live that we should take. My father is 89 years old and his second wife has left him. They have a marriage contract that indicates she can only leave the marriage with what she brought in. Now she is receiving support payments and she wants a payout. My father has a WSIB pension pre-1990. How will this be treated? It's an interesting question and it raises lots of issues. Number one, it sounds like there's a marriage contract. However, marriage contracts can be set aside. There's a case called Miglin and Miglin from the Supreme Court of Canada. And that case stands for the proposition that the contract had to be in accordance with the Divorce Act, both at the time that you entered into the contract and at the time of the review. The challenge for me when I see this kind of question is there's lots of information required because I see there's a WSIB pension, but I don't know that if that's the only income source. If it is the only income source, then this person doesn't have a tremendous amount of money to pay support with. But if it's one of several income sources or there's significant income elsewhere, that may change my answer. And even if he had the WSIB pension on the date of marriage, and if it's not factored into division of property, then it would be income for support purposes. So there may be some exposure, but it depends on what the income is. And that would be providing the person could successfully set aside the contract. And that would be if the contract included a release of support, because the language this person uses suggests they each keep what they have. It doesn't necessarily say there's no spousal support. I know that was a complex answer. My apologies for being confusing, but there's a lot of issues moving on in that particular question. Rachel, from your perspective, going back to unbundling services, what do you see as the most common request for unbundled services?
I will get requests to draft pleadings very frequently. Either a client will come in and, they'll want me to draft an application for them or respond to an application by doing an answer. I would say that's probably the most common. That way, we discuss the opportunity for further unbundled legal services in the future, but that's often where it starts. The other one is I will have clients who sometimes have, drafted agreements on their own and want me to provide independent legal advice. That's a request that I get very frequently. And what I generally tell clients is, you give me an outline of a separation agreement that you want, and I would rather prepare it. I feel like it's going to be more affordable for you if I draft the separation agreement for you, because separation agreements that are found online are sort of template options. They have a lot of holes in them, and they're generally not great. So I usually tell clients that, it's probably going to be more affordable for them just to have us draft the separation agreement. And
quite frankly, when people go to templates, it's important to understand what the templates mean and what insertions need to be there. And people don't know how to do it. And I know it sounds easy, a lawyer saying people don't know how to do it, but there's been so many times that I've been retained to set aside or deal with agreements people drafted themselves, and it ends up costing them far more money dealing with the problems arising from it. Because at the time they may want to do the deal, and they both may agree to do the deal, and we can paper it in a way that the deal will most likely be enforceable versus the way they've structured it, so it makes it easier to set aside the agreement. The other thing I want to add that I at least have people speak to me about is coaching. Some people want me to help them through the negotiation process in an unbundled retainer. So it could be they're going to mediation and I'm not playing a role in it. It could be they're going to court, but they're phoning me for advice on how to approach the negotiation at mediation or court, what the law is. Sometimes it's to write an opinion letter. Because one of the things I find people don't appreciate is here in Ontario is probably one of the higher support jurisdictions, meaning if you're going to pay support, like I do, you're paying more than you would in most places. It's important to know that, because when you sit down to negotiate, you want to have an idea of what range you are entitled to either receive or what range you're obligated to pay. And if you're going to mediation and you don't know that, the other person may make a proposal that you think is outrageous, but from a legal perspective may be a great deal and you should grab it. So that's really, I find, a very important place for coaching. I see we have another question coming in. This one is from Twitter. Can I take my child with me when I leave my abusive partner to get a divorce? Well, again, that question has certain layers to it. If your spouse is abusive, being physically abusive to you, you have an option. You can call the police. If you call the police, your spouse will be arrested. They will be removed from the home and there'll be a restraining order, and they'll come back one time with the police to get their clothes. The downside to doing that is obviously you're going to create more conflict in terms of getting to a resolution, which will most likely cost you more legal fees, and certainly your former spouse with respect to needing a criminal lawyer and a family law lawyer. May impact your spouse's ability to earn an income if they need to travel and have a criminal record. So I'm not saying not to call the police, but it's important to be aware of consequences before you do. The second piece to that particular question is, if you're not going to call the police, can you leave the home and just take the kids? Because in the first question, if there's a charge and he or she can't come to the home, you can stay there. In the second scenario, you should not leave the house with the children unless you have a court order or agreement. Because if you do leave the house with the children, then you face the risk of your former spouse running to court and saying you took the child and ran, and seeking out an urgent court order. You want to do it the right way. The right way is either with a court order or with their permission. If you do it the wrong way, you are going to certainly increase legal fees when there's an urgent motion, and the optics of what you did may very well be viewed negatively by the court unless you have great evidence with the abuse. But if you do have the great evidence, then go to court and get an order. So if you have pictures and medical records, use that, go to court, or call the police. I hope that helps the person who sent us the question on Twitter. We were talking about coaching. Do you coach clients, Rachel?
Occasionally I do, yeah. People will come in and they might, be at the beginning or sort of in negotiations, often people will come in and they'll be in negotiations directly with their spouse. Even neither of them have hired lawyers yet. So I'll sort of coach them with information and sort of giving them a gauge of what a good settlement would look like for them. And also strategizing with them in terms of the negotiations. But yeah, like you said, also, if parties are attending at mediation, I find that often they might go without counsel, particularly if they're dealing with child-related issues. So often I will, have clients that come to me before and after, and we'll sort of unpack what happened at mediation and deal with, tying up any loose ends or things like that.
And again, this is a place, I know people are going to take this with a grain of salt because it's a lawyer saying it, but if you're going to go hire a mediator, hire a lawyer before, even if they're not writing anything, even if they're not communicating with your former spouse, get the information. Because when you go into the mediation, information is what's going to give you strength in the negotiation. You're going to know when to concede and when not to concede and how to conduct the negotiation from a far better perspective than walking in with what your own personal viewpoint of fairness is, because your own personal viewpoint of fairness may not be what the law says. And I see there's another question from Twitter, which is, what happens when both parties want to stay in the home? Well, this is a very common problem in family law, is that judges are very reluctant to make an order forcing one side to leave the home, which is called an order for exclusive possession. So it is very common that both parties will stay in the home until there's a final resolution. If both parties ultimately want to keep the home, well, there's a simple resolution. It's going to be sold. And a court will sell it eventually. It's just a question of, will they sell it on an interim basis or will they sell it on a final basis? I don't know. What do you think about that, Rachel?
Yeah, I agree. I was actually meeting with someone yesterday just for an initial consult, and that was exactly the issue. It can be really challenging for people because it's an uncomfortable situation once you separate from your spouse, and you're lucky if you have, a basement apartment where one person can live, but often that's not the case. So, we generally advise clients not to leave the matrimonial home. It's financially challenging because you're responsible for half the matrimonial home costs, and then you're potentially on the hook for rent too. So if you can, it is best to try to, resolve the matter while you're in the home, but it's not always an option depending on the circumstances.
And there's something I want to say is that clients frequently are stuck in the same home with their former spouse, sometimes for a year, 2 years. I can say from personal experience, I can appreciate how awful of a feeling it is when you come home every night and there's your former spouse and you have your kids. I know when I tell clients to stay in the home, how challenging and how difficult that is, and I can appreciate that. But from a legal perspective, if there's an issue about where the children are going to live, it's really important that you both stay in the home until you sort that out and sort out the payments, because when one person moves out, that's what creates the obligations for support to start. I see there's another question. We're almost out of time, so hopefully we have time to deal with this, which is there any advantage to filing for divorce first? That's a personal judgment call. Some people like being first because it means when you go to trial, you're the first one to start your case and you get a reply at the end. Other people will say, well, I prefer to be the one responding and I don't care that the other side gets a reply. And quite frankly, most cases resolve themselves before a trial anyways. So I wouldn't be worried whether I'm first in or not. I don't think it's the most important thing unless there's an issue of which courthouse you're going to, because you live in different jurisdictions and you want to get the courthouse. So being the first one in will determine which courthouse. I wanted to thank Rachel for coming on the show today. It's a pleasure having you.
Thanks for having me.
And the next Ask Andrew show will be at our normal time of 1 p.m. It's going to be on May 18th, 2017. If anyone has a request for a certain topic, then please feel free to email us at info@feldsteinfamilylaw.com or message us here on Facebook. And thanks everyone for watching. I hope you've enjoyed the show and learned something.